So far as I know, all of my legal work, while it may have been done in legacy of or in accordance with concurrent processes associated with other people that are members of the law, I do not believe that any of my arguments or any of my approaches are correlative with anything anybody else did, especially specifically at that time, i.e., they were in RIM or that I was participating in illegal or illicit access to their capabilities. There is one outline I have made for a formal motion. And at the time, it was very unique in terms of the resonance I had. I'd not had that specific umber, let's put it that way. And it was a particular approach that I do not believe I would have come up with completely independently on my own without having something, without acknowledgement that allowed for me to see things in a different way I had it before. Pretty much everything else I've done to me makes logical, linear sense based upon my own perspectives because I have a variety of perspectives I can potentially see things in, especially if I'm resonating. But this was completely independent. It was almost spontaneous, but it was a particular approach I had not encountered before and did not believe I would have come up without being able to have something else going on that I could access. And after I finished writing the outline and I looked at it, something told me that it was connected to the former Attorney General Alberto Gonzales. But I've never read anything he ever wrote. It's a specific thing. I checked out a book, but I didn't read the book while I had it. There was something, there was some reason. I've not intention, and it's not. There are other people who have been litigators or have been in attorneys general of the state or on another level or prosecutors or served a public service role as a litigator or prosecutor, and I have not read their work while they were in that role for political reasons because my need to have a relationship with them in their professional capacity is in connection with another position they hold now, and their refusal to engage me based upon their responsibilities for the role they have now prevents me for political reasons from accessing anything they did prior to that role. I.e., if you were an attorney general for the state and then you become a senator and you refuse to do your job as a senator, I am not going to try to give you credit in my efforts to try to address your fraud or your refusal to perform your duties as senator by reading, i.e., investing your past political capital in an effort to try to address what my needs are now. So there are certain people who I haven't read any of their opinions and I haven't read any of their cases. And it's an ironic thing because, at least here in Texas, that means I have to go back quite a way. But so far as I know, this is the unique thing. I've never had that this is a very unique experience. So I'm acknowledging that. So I'm saying I would acknowledge. We would acknowledge if there's any question. So far as I know, it's the only thing. I've never read anything he wrote, though. I've read a review of some of his case opinions, specifically regarding rendition and discussions or distinctions regarding torture. And I have read some elements of or aspects of opinions, or shall we say, opinions by justices in consideration of cases he was involved in, but I've never read any of his actual work. So whether or not that particular specific argument, which would be one of the other four that I'm talking about, may have been influenced by some perspective or argument he had, or at that time was concurrently connected to perhaps a lien on his estate, I don't know. But if the question were to come up, I would acknowledge it. And if there were an appropriate opportunity to move forward on that argument or on what that would be as a supporting basis for any of the other claims or any of the other actions I would be taking, then I would acknowledge that and I would seek to appropriately confirm that by reading what would be references appropriate in order to confirm or deny whether or not that had occurred. But so far as I know, it's the only situation like that. Anything else is either I have either actually read it and commented on it based upon my own capacities, um, or I would have otherwise acknowledged that that's the only one that I know of. So if there's any question about that, just understand that. If I went to your office or I emailed you and I said, I have these concerns or I need your help, especially if I did it more than once, and then at some point later, you've done what in regards to addressing my concerns as your constituent? It's very, very, very unfair situation to be in to think somebody believes they're entitled to serve as a public representative of people and call them their constituents, and then spend a considerable amount of time completely ignoring them and allowing for their work to be redistributed after it's been slandered. And then to do what when it comes to these secret processes? See, it would be different if we hadn't had 2 years at least where I've actively been watching, where what goes on in the craziness of my mind later materializes in media reports and sometimes even the congressional record of people that refuse to do what their actual job as my political representative is, and yet end up having manifestations in what's supposed to be credited as their work as a representative that are based upon slander of my life and theft of my efforts. It's different. It's very different.